It weighs, it ponders, and it decides.
It interprets and applies, and it's often called the last resort and final authority.
Do you know what it is? Hi, I'm Sid. Welcome to Democracy Rules. If you guessed the Supreme Court, you're right. The National Judiciary is the third branch of our government. Its job is to interpret and apply the laws of the United States. Why would this be important? Let's see what some of you have to say.
Hi, I'm Shavela. Why do we need the Supreme Court?
We need the Supreme Court to interpret the laws of the lower courts.
I have no idea.
I know the Supreme Court makes educated decisions on issues.
Because many people have different views of the society and how situations go, and we need someone to make an overall decision, and that's why we have it.
Originally, the United States had no national court system. Laws were applied by each state however it chose, if at all. Interstate disputes were usually decided by one state and then ignored by the other. It was a system that didn't work at all. So when the Constitution was written, Article 3 established a national judiciary. Where do you think we'll be without it? Let's go to our resident expert, Senator Les Miller, for a perspective on that. Senator?
Thanks, Sid. Joining me today is Chief Judge Manuel Menendez of the 13th Judicial Circuit. Judge, thank you for being with us this morning.
Thank you for having me,
Why is
Senator.
the Supreme Court necessary?
Well, Senator, as you know, we here in the United States enjoy the best form of government in the world. It's not perfect, but it's the best. And the cornerstone of our democracy is the Supreme Court. We have a system of checks and balances, if you would, three branches of government: the executive branch, the legislative branch, and the judicial branch. And without the judicial branch to keep the check on those other two, we wouldn't be enjoying the wonderful form of government that we have here in this country.
How do Supreme Court actions affect other courts?
Well, the Supreme Court, when they make a ruling, it sets a precedent. That's the word that we in the law profession use, precedent. And so once they make a ruling, that is the law of the land, so to speak, and when those issues or similar issues are then raised before lower courts, we have the Supreme Court decisions to guide us.
Has the Supreme Court ever had to go back and look at something they did before to change it?
By all means. One of the I guess, paramount decisions of the Supreme Court that affects our lives today, of course, was the case of the Brown versus School Board of Education in Topeka, Kansas. Earlier, there was a Supreme Court decision that had actually ruled that the separate but equal concept was fine. We could continue with that, but with some period of time, obviously, things changed, arguments were presented, and when that argument was ultimately brought before the court, it changed the landscape here in this country, education and otherwise, when they decided that decision dealing with integration.
What would this country be like without a Supreme Court?
Well, you know, it shapes a great deal of our daily existence, whether we realize it or not. If we didn't have the Supreme Court, obviously, first of all, we wouldn't have those checks and balances that are so important. The legislature could, whatever the political winds of the day were, they could just make decisions regardless of what the Constitution may or may not say. The president could take certain actions. With that in place, because they are lifetime appointments, some of them have been there for many, many years, and so that was the framers of the Constitution who designed it, set it up that way so you'd have some sort of longevity on the court, some stability, and it really gives us that type of stability.
Right. Well, how do Supreme Court decisions shape this country?
Well, I mentioned the Brown decision. That was a big decision. We just had a recent decision up in Washington, D.C., where the Supreme Court ruled on the gun control in the District of Columbia, specifically ruling on the Second Amendment and whether or not the right to bear arms meant the right to bear arms, or whether it was tied into a militia and whatnot. So they've done that. They've made rulings on capital punishment. They've made rulings on abortion. Well, they even decided Gore versus Bush, dealing with the presidential election. Right. So they decide all sorts of things that do, in fact, impact our day-to-day existence.
Now, let our students understand, Supreme Court's appointments are for life.
That is correct. The president, with the advice and consent of the United States Senate, makes an appointment, and that's with regard to all federal judgeships. They're lifetime appointments. They're appointed, and they serve with good behavior for life.
And they hear some really tough cases.
Oh, absolutely, very significant cases. That, all the cases that people file to try to get heard aren't heard. They are selective in what they choose to hear, and they're generally cases of major impact to the nation as a whole.
And sometimes it takes a long time to get those cases heard.
Sometimes it does, and sometimes it's got to be the right case, if you know what I mean.
Exactly. And we're going to get back to talking about some of those type of cases in a few minutes when we come back.
Certainly.
Okay, thank you. Sid, get us started.
Thanks, Senator. Today we're actually going to look at all of our courts, so we need some clarification before we move on. The Constitution created a national judiciary, but each state still has its own courts. We live under a dual court system, one national, one state. We'll look at the federal level first and then check out our own Florida courts.
Let's log on to constitutioncenter.org for a look at Article 3. It's pretty short compared to 1 and 2. It says, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." It adds that judges will hold office, quote, "during good behavior," and that they'll get paid. It defines the limits of its jurisdiction, and the last section classifies treason as a crime, with Congress authorized to set punishment.
Jurisdiction: the power or authority to interpret and apply the law. Treason: an open act against the United States or aid or support to enemies of the United States.
So the judicial branch is the Supreme Court and the federal courts created by Congress. Let's look at the Supreme Court first.
The first African American on the Supreme Court was Thurgood Marshall in 1967, and the first woman was Sandra Day O'Connor in 1981, and that's a fact.
The Supreme Court is the ultimate authority on constitutional, congressional, and federal law. It's made up of the Chief Justice of the United States and 8 associate justices. Justice is another name for a judge. Justices are appointed to the Supreme Court by the President, subject to the approval of the Senate.
A vote on a Supreme Court nominee is a lifetime appointment, and when the court decides, it is the law of the land.
Only a few original cases come to the Supreme Court each year, but around 8,000 cases come on appeal. The court only accepts a few hundred for action, because the justices more often agree with the decisions of the lower courts.
Appeal: a legal proceeding where a case is brought before a higher court for review of the decision of a lower court.
How much effect can Supreme Court decisions have on the way we live?
Under the Supreme Court are more than 120 federal courts. 94 of these are district courts, the trial courts of the federal system. These courts hear more than 300,000 cases every year. Cases are either criminal or civil, depending on the type of law violation in question. Most district decisions stand as final, but some are appealed. These cases go on to one of 12 U.S. Courts of Appeals. The next step is the Supreme Court. Check out uscourts.gov for lots more info.
So what kinds of cases end up at the Supreme Court? Let's check in again with Senator Miller. Senator?
Thanks, Sid. Judge, what type of cases go to the Supreme Court?
Well, the Supreme Court is an appellate court, basically. We have, when the Constitution was enacted, it created the Supreme Court, and then it provided for all other inferior courts that the Congress might wish to ordain and establish, and the Congress has done that. We have a middle-level appellate court that hears appeals also, and then we have our district courts, federal district courts, and those are your trial courts. We have, of course, a state court system too, which is sort of parallel. We have our state Supreme Court here in Florida. We've got middle-level appellate courts called our district courts of appeal, and then we have our circuit and county courts, which are our trial courts. That's where the facts are heard, the juries sit and work, and the lawyers come in and they argue their cases. The Supreme Court, both here in the state of Florida and the federal U.S. Supreme Court, those are courts of appeal.
Can decisions by Supreme Courts, be them federal or state, be appealed any further?
Well, you know, the cases decided by the Florida Supreme Court could, of course, be taken up on discretionary appeal to the federal system, up to the U.S. Supreme Court. The United States Supreme Court decisions, as far as being appealed within the court system, that's it. They're final, unless they, of course, rule differently in that case or another case. They can ask for a rehearing, but those are, I think, few and far between. We could, of course, if they ruled on a point in the Constitution, sort of an appeal would be to amend the Constitution. Although we've only done that 27 times, I guess, in our country's history. So it's not that easy to do, and it shouldn't be.
Exactly right. It shouldn't be an easy task, but there are a lot of people debating that issue also.
Yes, sir.
Can you give us some examples of cases involving young people?
Certainly, let me start with the state court system, because we that's where most folks who deal with the courts will come in, either the county courts or the state courts. And of course, young people, just like adults, can get traffic tickets, for example, at the very basic level. So we have our traffic courts they can come into. We have here in Hillsborough County two specific divisions, which are basically set up for juveniles to come into. One is the Juvenile Delinquency Division. If they find themselves in trouble, they're arrested, the charges are that they may have done something illegal, shoplifted, whatever. We have that division where we have judges in place dealing with just cases involving young people. We also have a division dealing with what are called dependency cases, and those are cases wherein there may be allegations that a child has been abandoned, neglected, or abused by his parents or caretakers, and so we deal with those with great frequency, day in and day out. Of course, they can get injured in an auto accident, be in court. They can sometimes they're charged as adults if they're serious offenses. So they come to court a lot under that type of circumstance. The Supreme Court recently decided a case involving someone under 18. That was a very serious case. The young man had alleged to have committed a homicide. It was a death penalty case, and in that case they ruled that if one is under 18 at the time of the commission of the offense, they could not be executed under the death penalty in that particular state. Another recent decision from the United States Supreme Court involving a young person dealt with parental notification in termination of pregnancy cases. So there's all sorts of ways. We all have issues that young people can find themselves in court. And I would encourage young people to go over to the courthouse and spend a morning or something just walking into a courtroom if something's going on and watch. It's a very educational process, I think, and it's somewhat entertaining and enjoyable.
I bet it is. I've been there quite a few times myself. Why should young people pay attention to the judicial decisions made by the state and federal level?
Well, it's not just the judicial decisions that they should be paying attention to.
Exactly.
I believe, really and truly, we need to be paying attention to all aspects of government, from the president, the Congress, our governor, lieutenant governor, our state legislature, our courts, because those decisions made by our governments affect us, affect our daily living, affect the amount of taxes we pay, the amount of freedoms we have, the speed limits, you name it. Everything that we do is somehow affected by government action. And if we don't pay attention, then we're really giving up this wonderful system we have, which is a democracy. And so it's an extremely important thing, and we have an obligation to those who came before us to continue it, and those who are coming after us to make sure that we leave them a legacy wherein it's a citizen that cares and is able to govern itself.
Great point, Judge, great point. I'd like to talk about a case that the students will recognize when we come back in just a few minutes. Sid, back to you.
Thanks, Senator. Okay, now we've looked at the basics of the federal court system. Let's jump down to the state. Like federal courts, State courts also handle both criminal and civil cases. The state has two criminal levels, felonies and misdemeanors. A felony is a serious crime such as assault, carjacking, robbery, or murder. Felonies are punished by large fines, long imprisonments, and sometimes even death. A misdemeanor is less serious, such as driving with a suspended license, resisting an officer without violence, or disorderly conduct. Misdemeanors are punished by a smaller fine and shorter imprisonment. Criminal cases are always initiated by the state against the accused.
I'm sure you've heard of state attorneys and public defenders. Well, Florida has one of each in 20 state judicial circuits. These elected officials handle criminal cases for the state. The state attorney prosecutes the accused, and the public defender defends accused people who can't afford an attorney. You've probably also heard of the burden of proof. The burden of proof is the responsibility to prove an accusation. In criminal cases, it is proof beyond a reasonable doubt.
Without the public defender, what would happen to accused people who can't afford an attorney?
Civil cases usually concern disputes between private parties or issues between private parties and government. These cases are usually referred to as lawsuits and are usually resolved with an award of money or payment of a fine. In civil cases, the burden of proof is by a preponderance of evidence.
Preponderance. A superiority in amount, importance, or relevance.
Hopefully, none of us will ever be in court. But many cases are in court every day, and I'm sure lots of those people don't think what they did was a crime. Unfortunately, ignorance of the law is not a defense. Let's go to Senator Miller for some thoughts on that.
Thanks, Sid. Judge, do you often encounter cases where defendants legitimately don't know they've committed a crime?
It's an interesting question. Well, often no, we certainly don't. And I begin also with telling you, if we're talking about criminal cases, of course, the defendant is presumed to be innocent to begin with, but we do get occasions from time to time where you may have, say, a new law, something that's complex and whatnot, and there's a question as to whether or not certain actions violate that law. We also have cases involving individuals who have their mental capacity is such that they have no idea what they've done, whether it was legal or illegal. So we do get a lot of those cases within the system where we've got defendants, individuals with mental health issues. And unfortunately, one of the biggest mental health providers in the country today are the county jails. We just don't have the money to have the mental hospitals in place and things of that nature to give these folks some treatment. So we're unfortunately housing too many folks with mental problems in the county jail. They're picked up for sleeping on the streets or battery hitting somebody, and they're doing things that they clearly don't know what they're doing. And some of them are, in fact, a danger to themselves or others. So there's where you get, I think, the majority of cases as far as the ignorance of the law. But as you know, ignorance of the law is no excuse, and it's really not a defense. We sometimes would consider it in court in mitigation of a sentence, for example. Somebody was convicted of something and there was a legitimate issue as to whether or not it was obvious that this was illegal or not. That's something the court could consider in imposing what type of sentence would be appropriate under those circumstances.
Well, you basically answered my second question. That is the ignorance of the law and the consideration of the law. But you answer that. But let's talk about a case that probably many people have seen, not only locally but across the state and this country, and that is the YouTube issue that we saw on TV with the young ladies over in Polk County that made it across this country, and right now that's probably in the courts. Can you kind of talk about that a little bit?
Well, I can sort of a little bit. I can talk about it. It's a pending case, so it would be inappropriate for me to make any comments, specific comments about the case, but I can give you some generalities about it. We all saw it on television. Obviously, I didn't really pay attention to YouTube until that case, and I saw it on TV. I said, "What is this YouTube?" So I kind of clicked in the other day. But that's an example of a case where you have juveniles who have been charged as adults. I touched upon that earlier in the program, and how that process works is most juveniles who are alleged to have committed crimes are in the juvenile justice system, where the Department of Justice comes to play, and the state attorney's office makes the ultimate decision. The state attorney, here in the state of Florida, we have 20 circuits, we have 20 state attorneys, one for each circuit, and he's elected to that office. He has a staff, he appoints many folks to work on his staff, attorneys who are prosecutors. They are the ones who make the decision as to what to charge, what type of crime, how many counts, and things of that nature. With regard to juveniles, they also make a decision as to whether or not that juvenile should be charged in the juvenile system or in the adult system. Obviously, it's much more serious if you're charged as an adult because the penalties are increased, the type of sanctions one faces are much more severe. So it's a decision that, considering all the facts and circumstances known to the state attorney, that he or she makes. In this case, the state attorney, for whatever reason, filed against these young men and women, or women, I guess, as adults, and that's where that case is going to proceed. And you, like I, will just sit back and maybe watch YouTube and see what happens next.
Interesting case, Judge. Interesting case, and we're going to talk more about another case in a few minutes when we come back.
Very well.
Sid, what's next?
Thanks, Senator. Now we'll take a look at Florida's court system.
I'm online at flcourts.org. It's a great site that has charts of Florida's courts and their jurisdictions. County courts are the starting point. Trials here involve minor civil dispute, misdemeanors, small claims, and traffic court issues. Next up the line are circuit courts. Circuit court trials involve felonies, family law, civil cases over $15,000, and juvenile cases. They also hear appeals from county courts. Above the circuit courts are the District Court of Appeals. These courts do just as their name says, handle appeals from the circuit courts by reviewing and again interpreting the law.
Judges ought to be more learned than witty, more reverent than plausible, and more advised than confident. Above all things, integrity is their portion and proper virtue.
Florida's highest court is the Florida Supreme Court, which is made up of a Chief Justice and 6 Associate Justices. This court decides Florida's Constitution issues, all capital cases, and public utility cases. It also hears appeals from the District Court of Appeals. Check out FloridaSupremeCourt.org for lots more.
Now, let's bring all this together and take a quick look at an actual case with no names or places, of course. It's from another county several years ago, and it's a good example of how the system works. You'll see, it's not just defendants that appeal decisions.
Defendant, a person, company, etc., against whom a claim or charge is brought in a court.
In this case, police received an anonymous tip that a young man had a gun at a bus stop. When they arrived, the police searched everyone and found the gun. The juvenile was arrested and charged with illegal possession of a firearm. In circuit court, the judge granted a motion to suppress the evidence of the gun because the police had acted from an anonymous tip. The state of Florida appealed the decision to the District Court of Appeals, which ruled the search was reasonable. Then, the defendant appealed to the Florida Supreme Court, which upheld the trial judge's decision to suppress the evidence. Had the state not accepted this ruling, the case could have been appealed to the United States Supreme Court. It's interesting how things turn out sometimes. Ultimately, it comes down to a judge's best interpretation of the law, regardless of how that may change outcomes. Let's check in one last time with Senator Miller. Senator?
Thanks, Sid. There's so many elements to consider when hearing a case. Let's talk about the Latin King case.
Well, we are and we aren't. Again, that's a case that's still in the court system, right. So I'm basically precluded from discussing any of the details, but it does serve to illustrate a point, that is that in a criminal case, again, we as judges are making decisions all the time, not just during the course of a trial. In that case, there were some motions filed ahead of time trying to get certain charges dismissed, which I think were ultimately dismissed. I'm going to give you some examples that weren't related to that case, since I don't want to be talking about it. But for example, in a case where let's say there's a confession, somebody confesses to something. The United States Supreme Court, a number of years ago, decided a very famous case that everybody knows the name, Miranda versus Arizona. Right. And everybody, you watch television and you hear people get Mirandized and whatnot. And of course, that's the advice of rights, the right to counsel, the right to consult with counsel before questions. And the court imposed that as a protection to the citizens so that under the Constitution, we cannot be compelled to incriminate ourselves. That's one of our constitutional rights. And so they put that in place and then created what they call the Exclusionary Rule, wherein if a court finds that a confession was coerced, that those rights weren't given, that confession is excluded. That oftentimes results in a case having to be dismissed. Same thing with searches and seizures. Our Constitution protects us as citizens against unreasonable searches and seizures. We need to have search warrants, for example, to search people's homes, and that has to be based on probable cause, suggesting that whatever it is that we're searching for is in fact there, and on sworn affidavit. So if you've got a case where there is something wrong with a search warrant, or if evidence was obtained improperly without a search warrant, oftentimes judges make these decisions before trial to exclude evidence, to dismiss charges, things of that nature. If the trial goes on, then the decisions we make during the course of the trial are the admissibility of evidence, and then if there's a conviction, obviously we need to determine what an appropriate sentence should be under the circumstances.
We have probably about a minute left. But,
okay.
What are the most rewarding moments as a chief judge?
As a chief judge, one of the most rewarding moments I get, and as a judge period, we oftentimes get to swear in new attorneys when they come into practice. And so this is at the very beginning of their careers, and their friends, their families, their loved ones, they all show up into the courtroom, and we have a swearing in ceremony. The local bar association now has started a program where once a year or after the bar exam, when the results are in, we have a little program over at the courthouse. Those who want to come over, we do that, and we swear them in. So that's a wonderful thing. As the chief judge, I also get the honor and the privilege of presiding over the investiture of new judges. Right. And that's another good thing. You get to see judges beginning their careers on the bench. So those are good moments.
Your Honor, I appreciate you being here. It's been a pleasure having you, and thank you so very much for being with us.
Senator, my pleasure to be here, and thank you very much, and thank you for your service.
Thank you very much. I thank you for that. Sid, Shavela, we're out of time.
Thanks, Senator. Well, that's a rundown of our courts, from the tops in the country to the ones in our own backyard.
Remember, democracy rules, and you rule in a democracy. We'll see you next time.
Democracy rules!